Welcome everybody. Thank you for joining us for today's online talk entitled Online Defamation and Social Media. My name is Wong, Chee. I am a senior associate with Moderator and Associates, and I will be your moderator for today's session. Now, before we begin, there is a video that I would like to share for everyone here.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Before we start today's talk, let me introduce our firm and what we do. Moderator and Associates is a mid-sized law firm that was founded in 1985 by Datuk Kwai. Our able team today comprises of 29 lawyers and a support team of 27. Datuk Mat is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, as well as individuals. We are a full-service law firm with corporate department, dispute resolution department, including litigation, adjudication, and arbitration. We do have a dedicated employment or industrial relations team and a department focused on servicing the needs of individuals and families, such as family matters, citizenship issues, medical negligence matters as well. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online service talks series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 pandemic, the MCO, we have since moved online in order to continue our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, as well as in-house counsel. Before I continue on, I would just like to remind everyone that this talk does not constitute legal advice. In the event that you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Please stay tuned to the end, as details will be given at the end of this talk. Now, I would like to now introduce our two speakers today. The first one who will be speaking today is our senior associate, Edwin. He's a senior associate in our dispute resolution departments. He holds a Bachelor of Laws from the University of London. He has graduated with certificate in the legal practice in 2014. He's admitted to the Malaysian bar in 2016. And his areas of practice includes general litigation, defamation, commercial litigation, professional negligence, and indemnity, as well as strata disputes, employment matters, and intellectual property. Our second speaker, Kirbasyini Chandran, is an associate in our dispute resolutions department as well. She graduated from Cardiff University and she has a certificate in legal practice as well. Her area of practice includes contractual and commercial disputes, strata management, personal injury, public liability, medical negligence, land reference proceedings, as well as employment law disputes. Without further ado, I will now pass the floor to Edwin. Edwin, the floor is yours.
Thank you, Chee, for the warm introduction. And thank you all for joining us, Kirba and I, for this online talk, online defamation and social media. Now, the aim of this online talk is to give a brief understanding to prominent individuals, businesses or personalities who commonly find themselves entangled in online defamation and how to navigate them effectively. To navigate this issue effectively, it's quite important for you first to identify when is a statement or a content defamatory. And that is why we'll be talking about a few key points, which is what is defamation. Next, I'll also be covering on when or how to identify online defamation, which then I'll talk about the common culprits and the common forms of online defamation. I would also be talking about when is it not defamation. So when you find yourself in situations where there might be content which is defamatory, sometimes there are defenses available to the offenders. And that is why it's also important to know when is it not defamatory. And if it is defamatory, what do you do? Then we will talk about reputation management. And Kirba will take over speaking about civil recourse and remedies. All right? Now let's begin. Now, before I talk about what is defamation, allow me to just give a brief introduction or rationale on the law of defamation. Okay? The law of defamation is always concerned with balancing the competing interests in protecting one's individual reputation or business reputation, and on the other hand, the freedom of speech of another individual. All right? So it's always a balancing act. Now, of course, in giving freedom of speech to an individual is not absolute. Okay? When someone's freedom of speech infringes another person's individual rights or individual reputational rights, then that is when the law on defamation comes in to safeguard these interests. Defamation is governed under the Defamation Act and common law. Common law basically means judge-made laws. The types of defamation, it can be broken down into two. You have your libel and slander. Now, libel is in defamation in a permanent form, whereas slander is defamation in a temporary form. Now, what this means is that in your online articles or your journalist news articles, when those are published online, those are always in a permanent form. Slander, on the other hand, is more, for example, in interviews where it's not recorded, not online, those can amount to slander. Now we know the rationale. Let's move on to what is defamation. Okay. Now, defamation, by its very definition, is the publication of an offensive or defamatory statement to a third party. And the three elements required in law to be successful for a claim of defamation is that the statement must first be defamatory. Number two, the statement refers to the plaintiff. And number three, the statement is published to a third party. Now, I know this doesn't give you a very good overview of what defamation is, but allow me to just briefly explain them. Now, first, the first element is, what is a defamatory statement, you may ask, okay? A statement, this is how the cases have defined what is a defamatory statement. The first is, it tends to lower a person in the estimation of right-thinking members of society generally. Not very helpful in trying to understand that. It exposes the person to hatred, contempt, or ridicule. It disparages, is able to discredit, and is injurious towards the person's reputation in office, profession, calling, trade, or business. Now, in the simplest sense, what this means is this: any statement which is false and it lowers or it tends to lower your reputation in the eyes of public is defamatory. Okay, I repeat, any statement which is false and it tends to lower your reputation in the eyes of the public is a defamatory statement. So that means that in the eyes of public, if someone has a reputation of being honest, truthful, and fair, and then comes a statement to say that he is corrupted, he's untrustworthy, that lowers his reputation from being an honest, truthful person to become a corrupted person, an unfaithful, untrustworthy person. That itself is a defamatory statement. Now, how does the court determine that the statement is capable of lowering your reputation in the eyes of the public? This is what the court will look at. The court will look at the meaning of the words in its natural and ordinary meaning conveyed to an ordinary person. That means if I say a person is untrustworthy, the courts will just look at the words untrustworthy. The courts would not introduce any other subjective value towards that statement. Again, it's an objective test. The subjective understanding of the words are irrelevant. If there's a special nature of understanding between the parties in a defamation, it is not applicable because it's an objective test. Now, the publication must also be read as a whole, not in isolation. What this means is that how many of us have always read articles by just the title and assume what the article is about? I'm sure many of us have that experience, right? So that is not necessarily the case in defamation action. The court will not only look into the article, the title of the article, but the article in its whole, not in isolation. So you have to read the article in whole and understand whether is it just an offending statement or the entire article is offensive, right? Because more often than not, you may find an article will contain two sides of the story. That would reduce the sting of the article and therefore it may not be defamatory. Now let's move on to the next one. If you recall, there are two other elements which is, apart from whether a statement is defamatory or not, the second and third element is there must be a reference to the plaintiff and the statement must be published to third parties. Now, what does this mean? Statement must refer to the plaintiff. If I make a defamatory remark, I need to make about a specific person. If I say something about B to C, then I'm making a defamatory remark referring to B. Okay, I cannot say in isolation or in vacuum, all lawyers are untrustworthy. Then there's no reference to a specific plaintiff. Then you may have trouble in filing a defamation claim. Now, the next thing is that the statements must be published to a third party. That means this is where the eyes of the public come from. Okay, there must be a person who is able to value your reputation, to hear the defamatory statements before it can be defamatory. All right, say for example, there are persons A and B in a room by themselves, and A makes the most condescending statements about B without any third party. Then it cannot be defamatory because there's no one to value the drop in value of the reputation. So statements must always be published to a third party. That means A talking about B, and there is a third party C to hear that. Now, I've talked a lot about what is defamation and all that. So now you are able to identify when statements published online can be defamatory and when it cannot be. But let me talk about when situations that are most common in online defamation. So you have your common offenders here, usually the journalists and media personalities. Often more than not, I understand because of the nature of their job, which is to publish news very quickly, urgently, and always the attempt to always sensationalize things to draw viewership or readership in their articles, they would have to exaggerate certain ideas. And in the course of doing that, sometimes there will be statements that would be defamatory. Next, we have your employees. Now, employees very commonly make online reviews about their former employers, or they make online rants about their employers, or they may be even online gossips. Now, these can also be defamatory. Then you have your streamers and YouTubers. These are your live content creators. Most often than not, whenever they go live streaming, they may be bombarded with hurtful comments by their fans, or not. Some of them not their fans. Streamers, between streamers as well. You have your online feud between one streamer and another streamer. Fans, as I've said. You have also your business competitors. Now, business competitors, they may hire fake online reviewers to give a bad reputation to your businesses, or it may come in the form of advertisements showing one product is better than another product. Then, of course, you have your social media online trolls. These are the uncontrollable third-party users who just log in anonymously and just make defamatory statements. Now, situations that may arise, common situations. You have your films, documentaries, mini-series, and adaptations. Now, I'm sure most of us are aware that there are many documentaries out there right now in streaming services about a particular prominent politician on corruption. There could be documentaries or adaptation mini-series on stalking individuals. There could also be documentaries on celebrities and some of their scandals. Now, those are some common situations where there could be defamatory. These documentaries could be defamatory. Why? Because usually they would say, of course, they would say based on real life events, but naturally, sometimes you would come across a situation where there's inaccurate depiction of events. Say, for example, you are embroiled in that documentary and you are that entertainment celebrity, and they make inaccurate depiction of events when you actually know what is the true events, right? They often also portray certain characters in a very negative manner. Why? Because again, to draw viewership. Sometimes we know that factual events may be a bit boring, and that's why they try to sensationalize, exaggerating that negative character to a certain extent to draw viewership, okay? There could also be situations on deceptive editing. Okay, this is when, for example, documentaries on interviews, you have particular person making two sides of the story, okay? Story A against the celebrity, story B, good things about the celebrity. But often you'll find that filmmakers deceptively editing out the good parts so that the negative can be highlighted and portrayed about the celebrity in a bad manner. That itself could be defamatory. Again, sensationalizing events, depiction of one side of story, and also comments not sought from the alleged party. This is when you're claiming about, let's say, the prominent politician being corrupted, but you do not seek comments from that alleged or corrupted politician. That is unfair, and that could be defamatory then. Now let's move on. Streaming. This is what I've said earlier. You have your streamers going online. Sometimes you will be doing your online streaming about either a product or your vlog of your daily vlog. And then sometimes you would get hate rating, means rates from fans under your comments section and bombarding you with hateful comments until you stop your live streaming, or harassing you to the point that you cannot control it and it becomes emotionally distressful for you, and then you stop streaming entirely. Those could be hatred as well. Now, of course, there's also the part where ongoing feud with other streamers. Now, this is very common when two streamers have the same type of content. For example, in fitness influencers, where you stream about your fitness lifestyle and you educate your fans about working out and all that, often you get another streamer criticizing what you have done. For example, this workout is not right, that person does not have a degree, that streamer is wrong, that streamer takes steroids and things like that. That can be defamatory. Okay, now I'll move on. Then you have your sports and entertainment coverage. This is usually against athletes. You have your interview traps. After your game, you have your interviewers coming up to you, making very derogative questions, luring you into making negative statements about yourself or about your character as a whole. Those could be defamatory. There's also the part on post-match analysis. How many of us have always looked at post-match analysis of your favorite football team and then start criticizing them together with the sport analysis? Okay, after the game, they would say, oh, team A is supposed to do better than team B, but team A, this particular individual has earned a high salary, but is always performing so bad. He's not taking it seriously. He's drinking too much. Those can be defamatory, okay? You also have your trash talk. Now, what I mean by trash talk is very common in combat sports, where in the spirit of competition, one opponent speaks down to another opponent. Now, I think in the usual context of competition is fine, but when it becomes personal, about your personal life, which has nothing to do with competition, for example, that person is taking steroids, that person plays unfair, that could be defamatory as well. Now, you also have allegations of cheating. Sports players are also always open to allegations of doping, taking illegal substances to boost their performance, hacking. Those are for the esport players where they are always alleged using hacking because their performance are so good, or they have done something which is not right or against the rules. And then you also have players being alleged for match fixing. This is when you say, oh, player A is supposed to be this standards and that standards. During competition, he always falters. I think he's most likely doing some match fixing. Those could be defamatory. Now, what about our business individuals or individuals who have businesses? Now, there could be defamation in fake and false reviews about your product. You'll be posting in your social media, you'll get reviews after reviews of fake online people. Sometimes it could even come from your competitors. That is when you may seek an action for defamation. Review through influencers as well. Now, some of these social media personalities, especially in YouTube and TikTok, their entire content is made only to review products. So for example, they're reviewing Apple products. They would always bash about Apple products, and then suddenly they talk about better products, the competition products such as Samsung and all that. That Apple could probably look into defamation. Product advertisement is what I said about earlier. You have one product and you try to talk bad about another product by showing, during advertisement, you show a comparison of two products. Although you don't highlight it clearly that it is product X, you say that, okay, this product is not so good, but the colors and depiction of that product exactly resembles product X. So you say that this product is not so good, that my product is better, don't use this product, sort of thing. So advertisement can also cross towards issues on defamation. There could also be defamation when it comes to relationship with your business, special relationship with your business partners and vendors and funders. Sometimes your competitors will send comments or something through communication, online communication, that, look, this company X is doing this kind of corrupted practices. Their financial standing is very poor. They do not pay their funders or their suppliers well on time and things like that, which may scare off these suppliers and funders. And then from that, you may lose your business and it affect your business. So you may even consider defamation on those scenarios. Now, workplace defamation. This also happens very frequently. You have your online office gossip. You have your online rants about certain employees will rant about their employers online, and then they'll gather support from either ex-employees or present employees to talk bad about a certain employer. That might affect your business as well. It might affect you in terms of hiring. It might affect you in terms of your business relationship with, again, your suppliers or your special relationship with your other dealers. Now, there can also be situations where employers give negative online reviews on external websites. These are your glass doors. Many more where most of the time when you see negative reviews, it's very exaggerated. And what can the employer do? Because you know that prospective employees will always be looking at those reviews before even applying in a certain place, right? So we have talked about what is defamation. I've also shown you who the common culprits are. I've also shown you scenarios where defamation usually occurs. Now, let me just run through you one of the most important defenses to defamation. That means, when is it not defamation? There are many more other defenses, but I will only be speaking to you about one defense, which is very apparent. When is it not defamation? When it is the truth. When the statement completely says something which is true. So for example, if I say the streamer B is taking steroids, you shouldn't follow him as a fitness influencer. And if I have proof, if I have documentation and I have videos of him actively taking performance enhancers or steroids, then it cannot be defamatory because I'm simply stating the truth. So this is the defense of justification, the truth of a statement. Now, the defendant has to show that the statement made is true or substantially true. Must be substantially true, yeah? And this is governed under Section 8 of the Defamation Act. Now, obviously, there are a lot of other defenses, but because of the shortage of time, I would not be covering them. So I have now brought you to first identifying what is defamation, also who are the common culprits, what are the scenarios of defamation, and also when is it not defamation, when is the truth. Now, what happens when you find out that there is a defamatory statement and it's not the truth? For a fact, it's false. what do? This is when we come in to try to protect your reputation. Now, this is what I call reputation management. Now, we know that online statements and social media has a huge impact and influence over the public. So it's very important for us, especially prominent figures, celebrities, or streamers, to often monitor, manage, and respond to reshape the public opinion swiftly and promptly. Why? Because the longer you let it stay there, the longer your reputation may decay and will affect your business or your reputation as a whole. So in general, how to deal with negative and offensive statements? First, read and familiarize yourself with the related social media community guidelines. Most of the social media will have their own community guidelines. So it's very important for you to familiarize yourself with that. The second one, you must always stay calm and don't react. Thirdly, document and preserve evidence. Now I'll come back to all this one by one later, but just let me go through them point by point first. Report the offending user. You can also adjust your social media settings. You can also make your statement or version of the story. Okay, when things go viral and uncontrollable, that is when you decide you have to make a statement or version of the story. And last but not least, you consult people like us, lawyers. So community guidelines, why is it important? For example, this is one of the examples we got from Facebook and Instagram. In the community guidelines itself, the statements which I've highlighted, we remove content that contains credible threats or hate speech content that targets the private individuals to degrade, shame them, to blackmail or to harass, and repeated unwanted messages. Now, this could be defamatory statements as well. So if you familiarize yourself with that, even before considering or attempting to pursue legal action, you can always go back to the community guidelines, report that particular user or streamer or any individual who has made the defamatory statement, and seek redress or help from these social media platforms. This goes hand in hand with reporting the user. I've also put down an example in Glassdoor where the employers can consider doing this, can consider flagging that review so that other prospective employees who read that might take a more cautionary value on the review itself. So you can see in Glassdoor, they have guidelines on how to report a content, to report the content within the Employee Center, go to the Employee Center, click on reviews title, and so forth. This goes hand in hand with understanding the community guidelines. Next, one of the most important ones is don't react. Now, you want to avoid reacting and engaging with an offender. Okay, I know it's very difficult when you receive hate comments and defamatory statements, you would always want to react emotionally and try to clear your name and things like that. But always take a step back, pause and evaluate the situation. Why? Do not immediately refute and retaliate with harmful comments, statements. Why? Because that can jeopardize your position. How, when you intend to file a claim, if you make hurtful and defamatory statements back, your claim may not be successful. Or you may make defamatory statements instead as part of your response, and that would open you up to counterclaims. It escalates the situation. Sometimes the distributorship or the readership is so low, but because of how you reacted, it escalates the whole situation. Now, this is what we call the Streisand effect. Streisand effect is where a case was brought by our Barbara Streisand against a photographer for actually filming the Barbara Streisand and her mansion. So she brought a claim because they said that it was harassment, defamatory, bullying, and so forth. And so she had enough, and then so she filed a claim against the photographer. But one of the important things to note was that when she filed a claim, the amount of people downloading the photo was only 4 people, 4 including their lawyers. But when it was filed, it garnered so many viewership where it was recorded to be downloaded 400,000 times. So the fact of Barbara Streisand trying to censor this issue has made it open up to more criticisms and made it more viral than intended. So you always have to assess the situation. You must assess the volume of circulation. If it's not widely circulated, then you may always consider, okay, how do we take this? Would reacting or would me filing a claim cause a Streisand effect? Next, you also have to determine the person making a statement. If the person making a statement does not have good standing and is not taken seriously, then there wouldn't be a point for you to try to react or respond emotionally. That would actually put you in a worse situation. Now, document and preserving evidence. Now, gathering evidence is essential to build a case against the offender. Why? because we know that it is very fast. Online defamation is very fast. Sometimes when you file a claim in court, if you do not preserve this evidence, the user may remove their defamatory statement. They may remove the content without you having any evidence later to prove in court. So what precautions must you take? If you find something which is possibly defamatory, especially during a live video, consider downloading or recording the video. Note the visible timestamps in the video. Capture screenshots of defamatory comments, the date and time, which is very important. You can also capture screenshots of the amount of viewership, which also then supports your claim later. For example, if it's viewed 1 million times, then you capture the fact that it's viewed 1 million times. That would support your claim later and would increase your damages. Collect screenshots or collect any relevant information about the profile, the user profile. If it's anonymous, then it's going to be very difficult. As much as you can take information or you have information of the defamer, the better it is. Okay, save the URL. This is where, in case it is removed, it is better to have a URL than not. You can also adjust your social media settings. You may set your profile private, but of course, if you're celebrities and whatnot, that would not be ideal. But what you can do is you can limit information about what is publicly available or not. You may also remove offending statements. You can set your moderator preferences. This is for your streaming services or your live services, your live streaming, where you can have moderators to monitor hateful comments and to block users. Of course, you can then again block users. Now, what happens when you encounter a situation where the matter becomes viral? Often a product something about your product or your services become viral and you have no forms of control over how it's going to be circulated. That means you try to block one user, another user reposts it and so forth, and you cannot control it anymore. What do? Then you would have to seriously consider making your side of your story, which is making your statement. So you issue your statement to inform the public of your version of the story. You get help from experts, lawyers, or a PR person. Your statements must be factual. Don't try to be emotional. It's always good to be factual about what happened and all that. Most importantly, contain any defamatory remarks against the defamer, because this will work against you if eventually you file a claim in court. Now, it's also important to address the defamatory statement and the falsity of the statements. So if the statement has made something false about your product, address them to say why is it false, and to put the actual truth out there so that people understand it better. All right? This making your statement, in other words, pacify the situation from it getting more viral and rather than keeping quiet. Last but not least, you can always consult a lawyer like us. We will help you analyze your options because we are more legally adept towards the situation. We will help you analyze what options you have based on the statements that were published and also your reputation and so forth. We will also provide you legal guidance. We will preserve your privacy. And most importantly, as lawyers, there would be a certain pressure to the defamer, because when a letter comes from a lawyer or when a lawyer issues a statement on behalf of their client, it stands to inform the offender that, look, our client is taking this seriously. And if you do not remove, we would take legal measures. So I will pass the sharing session to my colleague, Kirba, who's going to be assisting in talking about the remedies and also civil recourse.
Thank you, Chee and Edwin. Good afternoon, everyone, and thank you for joining us today. So in this part of the talk, I will be covering what you can do if you are concerned that someone has said or published something about you that is untrue or is defamatory to you. Now, there are several courses of action that you can take. Firstly, you can issue a cease and desist letter to demand that the defamer immediately stops making or publishing the defamatory statements. Secondly, you can file a civil suit seeking damages and injunction. And alternatively, you can file a complaint to the relevant authorities. We will start off with a cease and desist letter. Now, a cease and desist letter is a formal document sent to an individual or organization instructing them to stop engaging in a specific activity that is considered harmful or unlawful. In the context of defamation, a cease and desist letter demands that the defamer immediately stop making or publishing false statements about you. Now, the purpose of issuing a cease and desist letter is to serve as an initial cost-effective step to resolve the issue without going to court. And some of the key items that should be included in a cease and desist letter are, firstly, the statement of defamation. The letter should clearly state that the actions or statements in question are believed to be defamatory. This sets stage by identifying the harmful statement. Secondly, it should include a demand for the immediate removal of the defamatory content to prevent further harm. Now, this can help to mitigate the damage to your reputation as quickly as possible. Thirdly, there must be a request for information. So you should also ask for details regarding the readership or distribution of the defamatory content. This will help in understanding the extent of the damage and the audience that was exposed to the false information. Fourthly, the letter should contain a non-publication undertaking. So this should require the defamer to undertake not to publish the defamatory content again or to republish it in any form. This is a very important step in preventing future harm. The fifth thing is there must be a demand for an apology and a declaration. This will help in setting the record straight and restoring your reputation. Lastly, there must be a publication of that particular apology. So the letter should specify that the apology must be published with equivalent prominence to the original defamatory content, and it should be approved by you prior to publication to ensure that it accurately addresses the harm caused. Now, by issuing a cease and desist letter, we can swiftly and effectively protect your rights and reputation. The second recourse is to file a civil suit and seek for damages or injunction. Why would you want to do this? Is because pursuing a defamation lawsuit can be worthwhile if you can show that the false statements have harmed you. Now, beyond the distress caused by having lies spread about you, defamation can tarnish your reputation and potentially result in financial losses. So, for instance, if a potential employer checks your social media during the hiring process and believes that the defamatory statements that have been posted about you, they may decide against hiring you. And similarly, professionals may lose business if false reviews influence potential customers. The main objective of filing a defamation claim or suit is to obtain compensation for the damage done and to clear your name or reputation. Your remedy through a civil action would be damages, a public apology, and injunction to prevent the defendant from making further defamatory statements or republishing the defamatory material, and removal of the existing content from all platforms where it was published. The primary remedy for a defamation claim is monetary compensation, intended to address the harm done to the claimant's reputation, and the amount of damages depends on several factors which are considered by the court to determine the appropriate level of compensation to be awarded. The factors have been determined or decided in the case of Linghua Press against Tan Sri Dato Vincent Tan. Several key factors were highlighted that influence the assessment of damages. The first is gravity of allegation. And the seriousness of the defamatory statement is a crucial factor in determining the amount of damages to be awarded. So more severe allegations, such as accusations of criminal behavior, typically result in higher damages due to the greater harm to the claimant's reputation. The second factor is mode and extent of publication. So the manner in which the defamatory statements were published and the reach of the publication play a significant role. So statements made in widely read newspaper or on very popular websites can be considered more damaging than those made in less visible venues. The third factor is the extent and the nature of the claimant's reputation. So the court considers the claimant's reputation prior to the defamation statement. This means that a person with a strong positive reputation is likely to suffer more harm from defamatory statements compared to someone with a less established reputation. The court will also consider the behavior of the defendant. So the conduct of the defendant both before and after the defamation statement can impact the damages awarded. So if the defendant has acted maliciously or with reckless disregard for the truth, this could increase the amount of damages awarded. Similarly, if the defendant's behavior was particularly calculated to maximize the harm towards the claimant, this would also be considered in the assessment of damages. Next, the court will consider the absence of retraction of publication. So if the defendant refuses to retract the defamatory statements, this can cause more harm done to the claimant and may lead to higher damages. A retraction of the publication can mitigate some of the damages and show an attempt to remedy the situation. Another factor is an apology. So the court will consider whether an apology has been made by the defendant, and an apology from the defendant can influence the amount of damages that the court awards. A sincere and timely apology may reduce the amount of compensation as it indicates remorse and an effort to make amends. However, an insincere or delayed apology might not have the same effect. And lastly, the court will consider benefit to the defendant. Any benefit that the defendant gained from making the defamatory statement can also be taken into account. For example, if the defamatory statements were made to gain a competitive advantage or to increase the defendant's popularity or sales, this could result in higher damages being awarded to the claimant. We will now look at the trend of damages. In the case of Linghua Press against Tan Sri Dato' Vincent Tan, this case is notable for the highest amount of damages awarded in a Malaysian defamation suit, totaling to a amount of 7 million. This case set a significant precedent for the assessment of damages, emphasizing the severity of defamatory statements and the substantial impact that they can have on an individual's reputations. However, in recent years, we have observed that there has been a noticeable trend toward a reduction in the amount of damages awarded in defamation cases. The range of damages has generally been between 100,000 to 500,000. And some of the notable cases that have illustrated this trend is the case of Nurul Izzah against Tan Sri Khalid. Here, the court awarded 400 to 600,000 for statements made against Nurul Izzah regarding terrorism. And in the case of Lim Guan Eng against New Straits Times, the court awarded 300,000 for allegations of bribery against Lim Guan Eng. And in the case of Raut Australian Gold Mining against Malaysia mkini.com, the court awarded 150,000 for allegations or defamatory statements about pollution affecting health and environment. So what we see here is that the trend towards lower damages in recent years suggests a more measured approach by the courts in awarding compensation for defamation. While significant award may still be possible, the courts appear to be more cautious in ensuring that damages are proportionate to the harm caused. Now, once you have filed a suit, now in the meantime, pending the disposal of the suit, if the defamatory statement is so injurious that damages alone cannot adequately compensate the claimant, seeking an interim injunction can be helpful. Interim injunction is particularly useful when urgent action is needed to restrain the publication of anticipated defamatory statements or to remove the existing false publications. Now, an interim injunction is a temporary and discretionary remedy that can compel or forbid an act. It serves the purpose of providing immediate relief by halting the dissemination of harmful statements until a final decision is made in the suit. This ensures that the claimant's reputation is protected in the short term, preventing any further damage that could occur while waiting for the resolution of the lawsuit. To successfully obtain an interim injunction in defamation cases, the following tests, as established in this case of Ngoi Tiam War against Sito Chandran Berhad, must be satisfied. The first is that the statement must be unarguably defamatory. So the claimant must show that the statement in question is clearly defamatory and damaging to their reputation. The second is that there must be no grounds for concluding that the statement may be true. So there should be no reasonable ground to believe that the defamatory statement is true, and the burden is on the claimant to prove this. The third thing is there must be no other defense which can or might succeed. So the defendant should not have any other viable defenses such as fair comment, justification, or privilege that could potentially succeed in court. And the fourth element is that the evidence of an intention to repeat or publish the defamatory statement. So there must be clear evidence that the defendant intends to continue publishing or republishing the defamatory content, and this will demonstrate the urgency and necessity for the injunction. You have to satisfy all these 4 items for you to obtain an interim injunction. Now, obtaining an interim injunction in defamation cases is rarely allowed due to its stringent requirements and the court's cautious approach in balancing freedom of speech and protecting reputation. It has only been successfully granted in very few number of cases, and one of them being Rosli Dahlan against Dato' Lokman's case. Your next recourse is that you can lodge a complaint with the Malaysian Communications and Multimedia Commission, the MCMC. Now, the MCMC serves as the regulatory body responsible for overseeing communications and multimedia activities in Malaysia. They play a crucial role in enforcing laws related to online content and protecting the interests of individuals and businesses online. Specifically, the MCMC has the authority to investigate complaints related to fake news or defamatory statements and take appropriate action against offenders. Okay, to start off, you will first need to file a complaint with the MCMC. This can typically be done through their online portal. And when submitting your complaint, you have to provide detailed information about the defamatory content, including URL screenshots and any other relevant context. Once your complaint is submitted, the MCMC will initiate an investigation to assess the nature of the defamatory content and identify the parties involved. So this investigation may involve identifying the source, so they will work to determine the origin of the defamatory content and the entities or individuals responsible for it, and reviewing the content. They will review the content against relevant laws and regulations to determine if there has been a breach or if the statements are untrue. Now, if the MCMC finds that the defamatory contents violate the Communications and Multimedia Act or any other relevant regulations, they can take several enforcement actions. Firstly, the MCMC has the right to remove the content. So they may issue directives to online platforms or websites to remove the defamatory content. They may impose fines or penalties on the offenders if the actions are deemed unlawful, or they may even issue a cease and desist letter to the offending party to take down the publication or to stop the publication of the content. The relevant provision governing this is the Section 233 of the Communications and Multimedia Act 1998. Now, this provision makes it an offense for a person to use network facilities, network services, or application services to intentionally make, create, solicit, or transmit any communication that is obscene, indecent, false, or offensive in nature with the intent to annoy, abuse, threaten, or harass another person. It also covers initiating communications with the intent to harass, whether the identity is disclosed or not, regardless of whether the communication is continuous, repeated, or otherwise. So basically, this section is designed to protect individuals from harmful or malicious communication transmitted through electronic means. So in conclusion, addressing defamation is crucial for protecting your reputation and seeking justice for the harm caused by false statement, whether it's through issuing a cease and desist letter, filing a suit for damages and injunction, or lodging a complaint with the MCMC. There are several avenues available to seek recourse, and each method serves to halt the spread of these untrue statements, obtain compensation, and restore your good name. And understanding these options will empower you to take appropriate action against defamation and ensure that your right and reputation are always safeguarded. That's it from my side. We will now move on to question and answer.
Thank you, Edwin and Kirba, for an insightful talk. It seems like a lot of the statements that we make on a daily basis can be deemed in some sense. All right, I think we can move on to the Q&A session. I do see some questions in the chat box as well as the Q&A box. I think I would like to kick off with a question that I have in mind just now that is related to what, Edwin, you mentioned just now. I think you have mentioned something about how a statement can be deemed defamatory is where, say, for example, in a room where A and B are in a room and then A makes some derogatory comments or remarks against B if there is no third party in the room, it cannot be defamatory. So the question that I have in mind is, what if there is like a CCTV, and if it's recorded, and maybe it's circulated subsequently, can this be online defamation?
Thanks, Chen. So definitely if it's recorded in the permanent form, and if it's circulated, then it can be defamatory because there's publication to third parties, as simple as that. That answers your question. So make sure that if you want to say something negative about someone, make sure there's no CCTV or any recordings.
I will take note of that. I will now move on to some of the questions that the participants have asked. There is a question by an anonymous attendee. The question is, may I know whether a resigned employee who has posted some bad remarks against his previous employer in Facebook or WeChat without specifically naming the superior, but those colleagues in the company knows who the superior is, does this constitute online defamation?
Yes, you don't have to specifically name the person. If, like I said just now, the test is what the ordinary person would read it as. So if the ordinary person being your colleagues or your other workforce understands clearly that this message is attended to a particular superior, then it can be defamatory.
All right, thank you. I will move on to the next question. This is from Jess Baines. What is the position of bad reviews by clients for businesses or services? Kirba, do you want to take this?
In terms of bad reviews, in defamation, truth or fair comment can be a defense. So if the statement in the review is true, then the reviewer is not liable for defamation, regardless of the potential harm that can be caused to the business's reputation. Also, if the review is an honest opinion based on true facts and is not made with malice, it is generally protected. So for example, a client expressing dissatisfaction with poor service or low product quality based on their actual experience, it will usually be considered fair comment.
Moving on to another question from an anonymous attendee. Can gossiping via WhatsApp about a colleague be considered defamatory? Edwin, you want to take this?
Sure. Again, yes, it can be if the gossiping spreads to another party. Of course, it can be B and C making gossiping something negative about A. Sure, that is defamatory, but A has to come to knowledge about that. In practical terms, A has to come to knowledge about that, and then A can decide to take the necessary action. So the necessary action may not be always a civil suit, because although online gossips can be defamatory, sometimes you would have to consider the costing in terms of taking a legal costs, legal proceedings, and your other civil recourses. But what you can do is perhaps to inform your employer about the misconduct, which is the gossiping about you, and it can be defamatory, and you take that seriously. But definitely gossiping about a third party with another friend is, especially if it's negative and if it's false, that can be defamatory.
There is a question from Adrian Leong. She's asking, what protection is there for civil society organizations, activists, or journalists from defamation suits filed by corporate actors levying defamation or slander charges to silence criticisms? The balance of power in terms of financial resource, time, energy is vast and highly imbalanced. And then I think she gave an example of Sam Ling's lawsuit. I think this is in Mary against Safe Rivers.
Yeah, higher standing or the prominent business person or politician will always have the power to always exert or to censor these issues. But as a journalist or a media company, what you're afforded is a defense of the Reynolds privilege. Okay, what you can do is that you can always publish these either documentaries or articles or so forth or news, but there must be what we call responsible journalism on your part. That means there are actually 10 factors. They are non-exhaustive. That's be considered by court before you are found defamatory. So what you can do is always important as a media and journalist is to always verify, to make as many verification of the facts that you're trying to allege. Try to not sensationalize the issue too much. One of the more key important factors is to always seek the comments from the person you are alleging something. Always seek their comments. If they refuse to comment, always include that as part of your article to say that we have sought this and this comments. They have refused to answer. Always try to include the other person's side of the story as well. Even if they refuse to comment, there could be articles, other articles already published by the offended party to state their side of the story. So it's always good to have a balanced story instead of pure story claiming one party or trying to allege something about the other party. So verification of facts, your source that you relied on, comments sought from plaintiff, these are some of the key factors that you should consider before making any statement which can be defamatory about any prominent individual or any business. That answers your question. Thank you.
Thank you, Edwin, for the answer. Seems a comprehensive answer to the question. I have to apologize to the participants who have posted your questions in the chat box as well as the Q&A box. I have just been reminded that the talk has gone past our usual time. I do have to end the session, unfortunately, but we will take into account the questions that we have that you have posted, and we will also get the speakers to answer them. Either maybe they'll reach out to you to respond to your questions. I do have to move on to the conclusion of the talk, which are some announcements. I would just like to make some announcements before we conclude the session. Firstly, there is an upcoming talk, I think next week, which is on the 7th of August, On a Wednesday, it's organizing successful events, legal considerations. This will be by our senior associate Tommy Wong and our associate Mira Masho. I believe if those who want to organize events, I think you should tune into this. It will be an informative one. And you can see there's a QR code for you to just scan it, and then you can just sign up for this talk. Next is please fill in our feedback form. Tell us what you thought of our talk. The link to the form will be posted in the chat, as well as, or if you can see the slide here, we have some social media accounts. So please do follow or like to get informed of our updates, for example, talks or articles that we will post on our social media accounts. Now, moving on to my third announcement, which is if you like to speak with our lawyers, we do offer a complimentary consultation. As I mentioned at the start of the talk, we have a complimentary consultation up to 30 minutes over the telephone or video conference. Please fill in the form on our website. The link should be posted in the chat box as well. I believe you can also just scan the QR code to go straight to the form. Lastly, to our guests, thank you for joining us. We hope you have found today's session informative and useful. I would like to thank everyone, and I hope to see you at our next talk. Thank you. See you.